Okay, welcome to the last session for the conference today. I'd like to begin by acknowledging the traditional owners of the land on which we meet today, the Kulin Nation, and recognise that these lands were never ceded. I'd like to pay my respects to elders past and present and extend that respect to any Aboriginal and Torres Strait Islander peoples who are here with us today. And, as others have done before me today, I support a treaty for the First Nations peoples of Victoria. My name is Julie Debeljak and I'm an Associate Professor at the Faculty of Law and an academic member of the Castan Centre for Human Rights Law. Our third panel discussion today is on the tensions of free speech and its constraints. I'm very excited to welcome three excellent speakers to discuss this topic, and we'll be exploring truth in political advertising, the responsibilities involved in free speech, and the complexities of free speech in an artificial intelligence-powered world. So our first panel speaker is Professor Luke Beck. The federal government has promised us that they're going to introduce federal truth in political advertising legislation modelled on laws that have existed in South Australia since the 1980s. Luke's presentation will outline how these truth in political advertising laws will work legally and practically, and he'll bust some common myths. Luke is a Professor of Constitutional Law at Monash University. He's also an academic member at the Castan Centre and a recently former Associate Dean of Education for the Faculty of Law. He got us through COVID lockdown. We love Luke. He also teaches units in constitutional law, law reform and public advocacy. He's a regular media commentator, and I welcome Luke to this podium.
Thanks, Julie, and thanks to the Castan Centre organisers for inviting me to speak today. So, as you probably know, it is perfectly legal for politicians and others to lie to you in political campaigning and political advertising. And we've been talking in Australia, talking about that being a problem for years and years, decades and decades, in fact. I found a little factoid the other day that every report into a federal election conducted by the Joint Standing Committee on Electoral Matters since 1983 has raised this issue. We have been talking about this for decades. So we all know the broader background of deceptive and misleading advertising rules. Businesses, corporations, others engaged in commerce are not allowed to engage in deceptive and misleading advertising when they're selling their products, their goods, their services to us. We can complain to the ACCC, action can be taken, what they're doing is unlawful. But there's a carve-out, there's an exception. Those laws only apply to commerce. They do not apply to politics. Now, there was an attempt that someone made to have those laws, or test whether those laws apply to politicians, and the court said, well, no, because engaging in political advertising is not selling anything. So deceptive misleading advertising laws do not apply to politics, and that's a problem. But there's one exception. You're not allowed to lie to people or deceive people about how to fill in the ballot paper. You can lie to them about everything else, but not how to fill in the ballot paper. So if you have an ad that has a tick or a cross on your sort of sample ballot paper, that's breaking the law, because as we know, you've got to number the boxes rather than tick or cross. But you can lie about your own policies, you can lie about your opponent's policies or their record or themselves. Lies are legal in politics in this country, except in South Australia and the ACT. So South Australia has had what people generally refer to as truth in political advertising laws since 1985. And the ACT has introduced laws from 2020 modelled on the South Australian law. And these laws do three main things. First, it makes it unlawful for political advertisers and others to make purported statements of fact relating to politics that are misleading to a material extent. It empowers, those laws empower the Electoral Commission to request any offending advertisements be taken down or retractions be published, and empowers the courts to order offending advertisements be taken down or retractions published. Now, there's a really important distinction, and that distinction is between facts and opinion. These laws, truth in political advertising laws, do not try to stop people expressing their opinions. Even the silliest, stupidest, uninformed opinions are not restricted by these laws. the laws only apply to purported statements of fact. So the distinction is between fact and opinion. And the courts in South Australia have had cases where they've tested this. So in 1995, there was a case about an election ad that said that the state government had a plan to shut down all public schools that had under 300 students enrolled. The court said that ad breaches truth in political advertising laws because the government never said that. The ad claimed the government made a particular statement. The government had never made any statement of that kind. That was deceptive, misleading, and therefore unlawful. By contrast, another case from South Australia where a leaflet was handed out and distributed to voters saying that a particular politician was soft on crime and therefore you shouldn't vote for him and you should vote for his opponent. And that politician was very upset about that ad because he wanted to put on a tough on crime persona. That was his political persona. And so he went to court and the court said, no. We're not getting into whether you're tough on crime or soft on crime because that's just a statement of opinion. These laws don't apply to statements of opinion. Opinions can be expressed. Go for it. Only purported statements of fact are regulated. Those cannot be deceptive or misleading. But most cases don't go to court, right? And that's the same in most areas of law. Most cases don't end up in court. So as I said, the law allows the Electoral Commission in South Australia and the ACT to request that misleading or deceptive political advertisements be taken down. If a person chooses not to comply with that request, because it's merely a request, not an order, that's fine. But that can be taken into account by a court in determining the penalty if there's a prosecution. So there's an incentive to comply with requests to take down offending, deceptive, misleading advertisements. And the way this actually works in practice is that the South Australian Electoral Commission has an online form where people can dob in or report offending political advertisements, and they do. At the most recent 2022 South Australian state election, the Electoral Commission there got 117 complaints about misleading political advertising. Now, some of those complaints were about the one ad, so it's not that there was necessarily 117 deceptive ads. And the Commission found that in respect of 83 cases, there was problems. And in response to that, the Commission did a number of things. They issued 2 warnings, they requested 2 remedies, they made 11 requests that further publication of the deceptive ads stop, they requested 9 retractions be issued, and in 10 cases there was not enough evidence for the Commission to take a view one way or the other. And the Electoral Commissioner in South Australia has told Parliamentary Inquiry in Victoria that these laws work from the start rather than in a responsive manner. And by that, what we mean is that it changes the political culture. So it's not about punishing people or political parties and others. It's not about issuing fines or warnings. It's about changing the culture to stop lies and deceptive ads from the get-go. And in South Australia, the Electoral Commissioner there has said that the political culture, at least with the major political players, has changed. Generally speaking, they don't put out deceptive and misleading political advertisements. Because the point of this, of course, is to make sure that people are not deceived or misled. Finding someone after you've done the damage is all well and good, but it's better to prevent the damage being done in the first place, and that's how it seems to work in South Australia. Now, of course, there are arguments against having truth in political advertising laws, and there's basically 3 common arguments against. And the first argument against having truth in political advertising laws is the idea that truth is subjective. And now, there's 2 responses to that. The first is that we don't accept that kind of argument in the deceptive, misleading advertising space when we're talking about commercial matters. We don't say, oh, well, pharmaceutical company, truth is subjective, so you can put out deceptive, misleading ads. Oh, well, electrical goods company, truth is subjective, you can put out deceptive, misleading ads. But apparently we should say, oh, well, political party, truth is subjective, you should be allowed to put out deceptive ads. We don't accept that argument in one context, so it's not clear why we would adopt that argument in another context. The second reason why that's not a good argument is because truth isn't subjective, opinions are subjective. Your opinion and my opinion may differ, and that's perfectly fine because those are our subjective opinions. Truth in political advertising laws simply do not apply to opinions. If the ad involves an expression of opinion, the law doesn't apply at all. So there's no issue around working out subjective issues. The second argument against truth in political advertising laws is the freedom of speech argument. People should be allowed to say whatever they want, and the remedy for bad or misleading speech is more correct or good speech. Public debate, public discourse will fix things. And the problem with that is that, again, two responses. First, we don't accept that in the deceptive and misleading commercial advertising context. We don't say, oh, well, pharmaceutical company, you can lie, and the remedy for that is, you know, the journalists can point out in their newspaper article that what you're saying in your ads is wrong. The second response to that is the constitutional response. And so you may have heard about the implied freedom of political communication, which is Australia's sort of attenuated version of free speech in the Constitution. Now, the Constitution requires that there be freedom of political communication in Australia. But the purpose of that freedom is to ensure that voters can make an informed choice about who to vote for an election or about which way to vote at a referendum. An informed choice. So a law that protects the information being conveyed to voters to ensure that it is not deceptive and misleading actually is compliant, enhances the system of government that the Constitution requires. It's compatible with the implied freedom of political communication. And the courts in South Australia, when they heard a challenge to their laws, said exactly that. Truth in political advertising laws do not contravene the constitutionally implied freedom of political communication, and in fact, they enhance the system of government that supports the implied freedom of political communication. And the third and final argument against truth in political advertising laws is a more pragmatic implementation argument. And that's to say that, well, if we give the Electoral Commission the job of adjudicating, in many cases, about political advertising, we're drawing the independent Electoral Commission into contested political debates. And that might undermine public confidence in the independence of the Electoral Commission. And of course, if we compare Australia with other countries, one of the strengths of Australian democracy is our independent Electoral Commission and the public confidence in the independence of our Electoral Commission. So that's an important concern. But the experience in South Australia since 1985 has shown that that concern has no foundation. The people of South Australia don't think their Electoral Commission lacks independence. So we know that that concern is misplaced. And the Federal Parliament's Joint Standing Committee on Electoral Matters considered this issue in its report last year looking at truth in political advertising laws, and they said exactly that the experience of South Australia shows that giving this job of enforcing truth in political advertising laws to electoral commissions does not undermine their independence. Now, I started by saying that Australia doesn't have a federal truth in political advertising law, that it's legal for politicians to tell lies during federal political campaigning. That's true now, and it's been true for most of Australian history, but not all of Australian history. For less than a year, in 1983, there was a federal law that banned lying in political advertising federally, but it only lasted for less than a year. The politicians introduced it, and then they thought, oh no, not a great idea, we better get rid of this. And so it only lasted for a few months. So we know that federal parliament can actually get their act together and pass these kinds of laws. They've done it before. But they've just got to stick with it and not undo it. Now, there were some drafting problems with that law, and the solution would have been to tweak and amend the law rather than completely get rid of it. But in recent years, there has been growing momentum to introduce a federal truth in political advertising laws. There's been more than a handful of private members' bills introduced into the federal parliament. There have been multiple parliamentary committee reports looking into this issue and supporting it. And it is official government policy to say the government will introduce a federal truth in political advertising law. We're yet to see that, so we'll see if that policy actually gets implemented. So it's Albanese government policy, and interestingly, even though some of the strongest opponents of truth in political advertising laws federally in recent years have come from the coalition, opposition leader Peter Dutton in March this year said that federal truth in political advertising laws were, and I quote, probably welcome. So even the Conservatives think that these are probably a good idea. And from their point of view, it is, because they have been on the receiving end of some deceptive, misleading political advertising, which may have hurt them in some electorates and cost them some votes. So these laws don't favour one party over another. It helps everybody. But what about the other states? So South Australia has truth in political advertising laws, and so too does the ACT. Queensland also once came very, very close to having truth in political advertising laws. In the late 90s, they introduced a bill to emulate the South Australian laws, but that bill lapsed when there was a state election and the bill was never reintroduced. More recently, in Victoria, in 2022, a parliamentary inquiry here recommended that Victoria adopt South Australian-style truth in political advertising laws. The state government's official response to that recommendation was that it supports the idea in principle. So what does "I support this in principle" mean? It means they like the idea, but we're probably not actually going to do anything about it. But they are on record saying they think it's a good idea. So maybe there's some pressure to be had there. And there's currently an inquiry on foot in New South Wales where one of the terms of reference asks the committee to look into whether or not New South Wales should adopt South Australian truth in political advertising laws. So we can see that there is growing momentum for change in this space. And as we've seen with mis and disinformation around the world recently, it's probably about time Australia got its act together and finally introduced a federal truth in political advertising law. Thank you very much.
Thank you, Luke. Your message was clear. It's refreshing in this post-truth world to hear somebody talking about truth in political advertising, but it is alarming, the first sentence, you know, politicians are allowed to lie to us. It is just beggars belief. Anyway, thank you, Luke. Katharine, can you just make sure that we can hear you?
Yes, can you hear me?
We can hear you. Excellent, thank you. So our next speaker is Professor Katharine Gelber, who is joining us online, as you can see. Katharine's going to be presenting to us on the rights and responsibilities of free speech. Katharine is an Associate Dean Academic in the Faculty of Humanities, Arts and Social Sciences at the University of Queensland and former Head of School of Political Science and International Studies. She's got very many credits to her name, including being a Fellow of the Academy of Social Sciences in Australia. She was an Australian Research Council Future Fellow, and she's also been President of the Australian Political Studies Association. So her expertise is in freedom of speech and regulation of speech, with research projects into the regulation of hate speech, especially online, and other allegedly harmful speech. Her recent publications include a jointly edited book, Free Speech in the Digital Age, and Free Speech After 9/11, both of which are Oxford University Press publications. So I welcome Katharine to the stage, or to the screen.
Virtual stage. Thank you very much. I'd like to echo what Luke said. Thank you very much to the organisers for having me along on this very important topic. You might think that the topic, it feels like the topic of free speech has risen in prominence in public debate in recent years. In fact, 30 years ago nearly, when I started my PhD on this topic, people said, free speech, that's not a thing in Australia, is it? It's certainly a thing now, and in fact, that's been demonstrated empirically as well, which I'll talk about in a moment. So free speech is much more prominent in public debate, not only in Australia, but in other countries as well, like the United Kingdom and the United States. We increasingly see politicians routinely using the concept of free speech to justify their policy positions, even if those policy positions are quite confusing. And as I said, there's been a significant increase in the prominence of the topic of free speech especially since 2011, but especially since 2017. In fact, I did a study with a colleague where we did a search on the incidence of free speech or freedom of expression, freedom of speech in all capital city newspapers and the Australian newspaper from 2001 to 2021 as a proportion of the total number of news articles published in the same period in all of those outlets. And I mean, it's bumpy, but you have this really lovely line essentially going straight up. So if you think that free speech has become a more significant topic of public debate, you're right. So historically, free speech has a strong but mediated place in Australian in the legal situation, and in political culture. And unusually, of course, among liberal democracies, we don't have a federal Bill of Rights, and we don't have an explicit free speech protection in federal constitutional or statutory law. Of course, we have the implied freedom, as Luke has outlined. While research has shown then that Australians value free speech, Australia's historical approach to free speech has been premised on utilitarianism, which means that on the one hand, there's been strong public support for laws that can limit free speech in the interests of a public good, and on the other hand means that governments have quite a bit of leeway to restrict free speech in overbroad and concerning ways if they wish to do so, and there's very little ability to rein that in judicially or using courts and using laws. That ends up being a political argument. So the paradigmatic case of a law that is seen to act in the public good in restricting free speech, for example, is vilification laws, which are understood to protect vulnerable target communities from harm. And of course, there are plenty of examples of the latter, that is government overreach in restricting free speech, including the definitions and descriptions of allegedly terrorist speech in criminal law, and increasingly anti-protest laws across the country in numerous jurisdictions. So in spite of these vagaries, there has, I think, been a broadly consistent approach to free speech from governments for quite some time. And I think that broad, one of the things I'm going to talk about today is that broad consensus, I think, is fracturing. That broad consensus has demonstrated that free speech has been a consistently held value, but that appropriate restrictions have received considerable amounts of public support. I think the shift that we've seen in public discourse around free speech, especially in the last decade, is firstly attributable to the volume, but secondly, and this is important, that I think that discussion is more complex, more confused, and very inconsistent. So commensurately with the increase in the volume of conversation around free speech, I think we've got greater inconsistency in what people mean by it, and sometimes almost deliberate inconsistency. I think we see more often in Australia than we used to that free speech is used opportunistically as a mantra to cover political positions that either really have nothing to do with free speech at all, or where they do, they demonstrate broad inconsistencies in the application of any free speech principle. We've seen this in numerous recent events in recent years. In 2018, for example, the federal government launched an inquiry into free speech in Australian universities and subsequently implemented changes to the Higher Education Support Act, and every university in Australia implemented changes to internal policy making to ensure compliance with a model code. There were some good elements to all of this work. For example, there's a clearer distinction now in Australian universities and in the Higher Education Support Act between free speech on the one hand and academic freedom on the other. But overall, the purpose of this inquiry and its aftermath was to question whether universities or to put out into the public discourse the idea that universities were insufficiently protecting free speech. And it was an important finding of the 2018 inquiry that there was and is no free speech crisis in Australian universities. And indeed, the politicians who were most staunchly accusing universities of failing to protect speech around the time that inquiry was launched in 2018 and in subsequent years have in recent months been among those who've been most critical of free speech, of universities trying to find the balance between free speech and the right to free speech, the right to demonstrate, and appropriate limits on that right in the context of recent events on university campuses. In 2018, the Australian Federal Police also raided journalist Annika Smethurst and also ABC officers under a warrant which was later ruled by the High Court of Australia to have been invalid. This was widely held to be an affront to freedom of the press and has led, amongst other things, to a call for the enactment of a Media Freedom Act in Australia, which we currently don't have. And of course, we've had considerable debates around religious freedom, which have been bubbling along for many years, but which reached a bit of a zenith during and subsequent to the same-sex marriage campaign. And during and after that campaign, opponents campaigned hard for legal protections for religious freedom. And indeed, a central component of the No campaign was saying that the vote around same-sex marriage was actually a vote around freedom of speech. They alleged that the passage of same-sex marriage would in and of itself constitute a violation of the free speech rights of those who held a faith-based reason for opposing it. And another part of their campaign was that the freedom of religious expression among people of faith in Australia should be absolute, insofar as it should mean that any statement that was faith-based should be immune from action based on other laws, such as anti-vilification laws, for example. So there's been a real range of that's just a few examples. I could give you more examples, but they're some of the key events in this rising discourse around free speech in Australia. Research into these key events, including my own, but not only that, has shown that a key element of this discourse has been its internally contradictory nature. On the one hand, free speech is posited as important, drawn on discursively as a value to which we all aspire. And the background broad support for free speech that I referred to earlier is the basis for drawing on this public support. Free speech is posited as unassailable, a value to which the government is committed, and by extension everyone in the community should be committed. Yet there were other discourses that were simultaneously at play, one about the need to expand free speech protections and another about the need to limit free speech protections, and sometimes these even happened in the same discourse. So in 2018, as I said, universities were accused of not protecting free speech sufficiently and not adequately ensuring students were exposed to ideas and concepts that challenged their worldviews or were unpopular. The idea being that free speech was insufficiently protected. People of faith complained that they needed greater protection for free speech, even if the way that they couched their speech and the way that they chose to express themselves amounted to vilification. And it was posited very strongly that protecting free speech for people of faith required overriding existing limits on vilifying speech. But there was also simultaneously discourse about limiting free speech to prevent harm. In 2021, then Prime Minister Scott Morrison said, and I quote, "In a free society such as Australia, where we value our free speech, it's only free when that is balanced with the responsibility for what you say." During the raids on journalists, relevant laws were defended that way, and during COVID, laws that permitted deportation of someone based on their anti-vaccination views were also defended. So there were very strong inconsistencies and contradictions within the same discourses around free speech. So I think this means people are genuinely confused about where to draw appropriate limits on free speech. Perhaps that's a little bit unsurprising. These limits are not clear and bright, or the distinctions on where to draw the limits are not clear and bright. They can be complex, but there are ways to find a way through this confusion. I think people genuinely don't necessarily know what should be protected, what can justifiably be regulated, and what amounts to speech that's sufficiently harmful that it can be justifiably regulated. I think the public debate would benefit from a greater degree of clarity than we have now, and I'd like to reverse the direction of the debate, which I think is aiming towards greater confusion, not lesser confusion. The confusion is caused by political rhetoric using free speech as a catch-all for things a person wants to support without consistency of approach. And in fact, in 2001, Fred Schauer called this, in the US at least, called it First Amendment opportunism, and I think we are seeing free speech opportunism in Australia today. And also we're seeing the increasing use of free speech claims for activities that wouldn't have been considered to fall within the rubric of free speech under the consensus of the latter part of the 20th century. The examples for this are more international than they are in Australia, but I was shocked to read, and you can look this up, that the National Republican Convention the year after the January 6 insurrection described the January 6 events as legitimate political discourse. And also in the United States, but also in other countries, we've had a paradigmatic case of the baker who doesn't want to bake a cake for a same-sex wedding, and is in violation of anti-discrimination law by refusing to provide that service to same-sex clients where he, and I say he because it was a man in this instance, where he was prepared to provide that service to heterosexual clients. And he made an argument based on free speech, that being required to comply with anti-discrimination laws would violate his free speech. That really muddies the waters when people move discrimination complaints into the realm of free speech. So I think a useful way towards greater understanding and clarity on this debate is to re-emphasise the importance of the responsibilities that adhere to exercising a person's free speech, just as they're inherent to the responsibilities are inherent to every exercise of a human right. We know that the enjoyment of our own human rights can be, and often legally is, limited at the point at which our exercise of our human rights infringes on the exercise of human rights by others, and particularly on their exercise of the same human right as you're exercising. So the key responsibility here that adheres to the right to freedom of speech is the responsibility not to harm others with your words. And I would like to emphasise that being capable of harming others with your words is what distinguishes vilification from speech or language that is merely intemperate or vituperative or rude or mean or nasty. You can be mean and nasty, and it's really unpleasant to be at the receiving end of that. But that's different from being at the receiving end of vilification, which is defined phenomenologically and legally as speech that harms to a degree that is commensurate with the harm of other forms of discrimination. It's a form of discrimination that happens through words. So we all have a responsibility to use our words in ways that don't harm others. In the Victorian Charter of Human Rights and Responsibilities, it's phrased as the responsibilities to protect the rights and reputation of others and not to risk public safety. So there's a very clear directive there to protect the rights of others. We also know that free speech doesn't apply to everything we say. There are all, and by say I mean expressive conduct conceived broadly, there are all kinds of ways that we express ourselves that don't fall under the protections of free speech, generally speaking. That includes the way we dress, for example, as an expression of our personality. Free speech principles apply to the speech that is capturable as kind of political public discourse, the speech that Luke was talking about, the speech that is essential to our ability to form our own conception of how we want to live, what it is to live well, to make informed decisions. The shorthand version is to make informed decisions as electors. But there's a slightly broader version, which is how we make up our own mind about what kind of a society we live in and how we want to pursue that. So that's what free speech applies to. We know that speech can harm, and we know that free speech principles shouldn't apply to every expressive conduct that exists. In Australia, we've long held a view that free speech can be limited where the government is trying to secure human rights and dignity and to protect vulnerable communities from harm. This is the basis for our anti-vilification laws, and it's one way of recognising the many responsibilities that are inherent to exercising the right to free speech. There are other ways that don't rely on statutes. They rely on the day-to-day behaviour of those of us who are exercising this right in often very complex environments that lack bright lines of distinction between speech that harms and speech that might be intemperate or vituperative but doesn't harm. And this also relates, of course, heavily to the online environment, where a huge proportion of our communication now occurs, and where the responsibility to think before you click, before you respond to clickbait, before you put your private information out there for the world to see, all those, I'm not putting it all on the individual, far from it. I'm just saying that this is one aspect of the debate that has been overlooked, I think. So we all share in the responsibility not to harm others with our words, and I think those with a greater voice carry that responsibility most heavily. And so while it applies to all of us, I think those who have the loudest voices, the most widespread voices, the voices that carry the most weight because they get the media coverage and so on, carry that most significantly. I'll leave it there, and I'm very happy to take questions. Thank you.
Thank you, Katharine. I can't resist the plug for a Bill of Rights in this context. If we really are thinking about where we draw the lines between what is legitimate and illegitimate free speech, the sorts of frameworks that we get from human rights legislation at least give us a framework in which to discuss things, as opposed to Catharine's point that quite often we get inconsistencies and discrepancies in the debates around where to draw the line between legitimate and not legitimate free speech. So thank you, Katharine, for provoking those thoughts. Our last panellist today is Dr. Andre Oboler. Andre is presenting on balancing free speech and human dignity in an artificial intelligence-powered social media world. That gives me heartache. Artificial intelligence-powered social media world. He will consider the legal principles of appropriate adaptation and what this might mean in today's online environment. Andre is the CEO of the Online Hate Prevention Institute, which is a charity established in 2012 to tackle all forms of online hate and extremism. He's also an honorary associate in the law school at the La Trobe University, where he was previously a senior lecturer in cybersecurity law. Andre has served as an advisor to governments, companies, charities and individuals. He's an expert member of the Australian Government's delegation to the International Holocaust Remembrance Alliance, and he serves as chair of the IEEE's Global Public Policy Committee. He's also served on various boards. Andre is very well qualified to be speaking here today, given that he holds high degrees in both computer science and law, which are both clearly relevant to the topic he's going to be addressing. Welcome, Andre.
I thank the Castan Centre for the invitation to be with you today. There's a flyer that's just been handed out to you. I'm going to refer to it briefly. There's some QR codes on the back as well. I would ask maybe if we hold back not to get distracted with the QR codes just yet. But one of those does include, I think it's 4 examples. Thank you. 4 examples of hate speech generated by artificial intelligence. So when I talk about that topic, you have actual visual examples to see what we're talking about. What I'm going to talk about today really goes into the gap that Katharine just spoke about, which she said was underexplored, not given enough attention. So I want to look at this. I think both of the previous speakers, their topics are accelerated due to social media. We did some work earlier this year during the by-election, looking at mis and disinformation, which, given it was about a by-election, really comes to the question of truth in advertising. And we did that for a not-for-profit, and had very interesting conversations with them about the question of what is mis and disinformation in the context of political speech. And our definition was much broader than their definition was. And it comes back to this question of what exactly is protected, what is fact, what is opinion. And the good news is, although we found a lot of problematic content, it seemed to have absolutely no impact whatsoever on the way people voted. So, you know, I would argue overall these things can have a big impact. I think in the context of elections, the biggest protection Australia has is compulsory voting. A lot of the mis and disinformation overseas, you know, there's a common refrain in the US saying one political party should vote on Tuesday and the other party should vote on Wednesday. For those that know US elections, they're always held on a Tuesday. So if you don't get there on the right day, you're just not going to get your vote to count. So this whole idea of using speech to disenfranchise voters and promoting that through social media campaigns that are outright lying, in fact, about process, the one thing that is illegal in this country as well, you know, really is a big factor. and overseas at least can make a difference. The closest we got to that was during the referendum. The Electoral Commission did put out corrections to misinformation, telling people that their vote wouldn't count if it was done in pencil and they should take their own pen, because the pencils that were being handed out to them would lead to an invalid vote, which could be changed by the Electoral Commission. So with that, I will now actually get to my actual speech. So what I want to look at here is the legal principles of appropriate adaptation and what this means in today's online environment. I'm returning to a concept that I discussed in a graduate research paper I wrote about a decade ago when I completed a JD with the Monash University Law School. And that graduate research paper was published in a journal as Legal Doctrines Applied in Online Hate Speech in the journal Computers and Law. And I want to thank Professor Jonathan Conf, who supervised that paper and whose own prior work actually is reflected in the concept I'm speaking about today. The paper opened by saying, and I'm quoting exactly here, the application of legal doctrines to the problem of online hate speech, particularly in social media, is of growing importance to both the legal profession and society. That was a decade ago. This is still true today, and we're in many ways still feeling our way forward in this area. Not very much has actually changed when we talk about law reform. In the paper, I discussed 3 principles. The first one was about inclusion, and inclusion talks about the idea that content that is criminal offline should not escape criminality simply because it's now in the online environment. Historically, this has been a big problem because of jurisdictional boundaries, that online was just too hard. Even if the law theoretically applied, practically, it's online, it's not our problem, was the view often expressed, particularly by police at the front line before you can even move forward. The principle of generality that says that the existing law, rather than specialist laws, should be used whenever possible. So take, for example, the Racial Discrimination Act, Section 18C. The first case that applied that to the online context was Jones and Tobin, and was a case of Holocaust denial from the Adelaide Institute in South Australia. And the case took a decade to get through the courts. Okay, eventually, and then it took further cases to actually enforce the court's ruling that the content should be removed. Eventually, it actually became ineffective because the Adelaide Institute was just sold to a US organisation who continued to publish it from offshore. The third concept is what we're talking about today, appropriate adaptation. And this is the idea that conduct that is not criminal offline should only be criminal online if the nature or prevalence of the conduct necessitates a criminal response. Okay, so some things that may not be criminal in speech in the everyday world may need to be criminal in the online context. Today I want to focus on this idea, but also extend it beyond the question of the criminal law. Nationally, Australia does not criminalise racism. Okay, we have racial vilification laws, including criminal elements in some of our state laws. They generally involve a need for incitement to violence being part of that expression. But nationally, what we have is 18C in the Racial Discrimination Act, which is not criminal at all. But it is unlawful. So this is out of step with many other countries, where hate speech is a crime and addressed not only by human rights agencies like we have in Australia, but actually by police. A couple of weeks ago, I ran training, I was in Brussels, I ran training for police around Australia on hate speech targeting both Jews and Muslims. We had police from, I think it was about 12 or 14 different countries, including from Australia, participate, and they found that really useful. Okay, in Australia, that speech is only of relevance to police in the context of bias-motivated crime, where the hate speech may be an indicator of a factor in relation to other crimes, but not in and of itself. Other police who were present actually have to deal with hate speech as a criminal offence within their jurisdiction. In the online space, the additional protocol to the Convention on Cybercrime governing the criminalisation of acts of a racist and xenophobic nature committed through computer systems, that is the title of the document, it's really long, opened for signing more than 20 years ago. It calls for a range of online hate speech actions to be criminalised. So this idea of having criminal sanctions is far from new, but it is not what we do here. Many jurisdictions either have just completed or are in the process of completing legislative reform relating to online hate. In Europe, there is the Digital Services Act from 2022. The UK has the Online Safety Act from 2023. Canada has a proposed Online Harms Act that may become an act in 2024. These reforms all address hate speech provisions, often with criminal sanctions. In contrast, even as online hate has risen, Australia has continued to treat the problem as only an aspect of offline hate, therefore something to approach with the general law, which is non-criminal. The principle of generality and inclusion are therefore applied, but not the principle of appropriate adaptation. The Online Safety Act, here in Australia, covers cyberbullying of an adult and cyberbullying of a child, and these may involve hate speech, but they don't need to, and if hate speech is part of the bullying, it's actually irrelevant, other than the fact that the bullying is occurring, to the cause of action for, for those aspects. Group-based hate in the Online Safety Act is not covered at all. The Commissioner has no capacity under the law to act on content that is racially or religiously vilifying an entire group. It's just outside her remit. She cannot deal with takedown orders, for example, on this content. Okay. The gap is currently being considered by Ms. Dahlia Rickard, who is conducting a review into the Online Safety Act. That review is happening right now. I met with her last week. So why is appropriate adaptation needed? Or rather, why does the nature or prevalence of online hate necessitate a specific legal response? In framing such a response, how do we balance free speech and human dignity while taking account of the power of social media as demonstrated to date, and addressing the threat that artificial intelligence may play in exacerbating the problem as we go forward? Data from eSafety indicates that 14% of Australian adults were personally the targets of online hate. If we extend this to experiences of online hate, whether directed personally against them or as a member of a group, the number is probably closer to a third of people. Research in Australia has demonstrated that, and recent research this year from the United States Government Accountability Office has also come up with that figure for the US. There is a pandemic of online hate, one that specifically impacts minority and vulnerable communities, whether on the basis of race, religion, sexual orientation, disability, or other identity-based factors. Online hate has the ability to go viral, reaching many more people than similar hate in any offline setting outside of broadcast media, which has its own rules. The problem is also getting worse. Research by my organisation, the Online Hate Prevention Institute, found an increase of between 340% and 1,000% in anti-hate speech after October 7 and the terrorist attack compared to before. We happen to have a year's worth of data we'd been collecting that we finalised our data collection on September 30th, a week before the attack. So we were able to do that direct comparison. The reason I say it's between 340% and 1,000% is we actually monitored it across 10 different social media platforms, some mainstream platforms and some more far-right platforms. The lowest increase was at 340%. The highest increase was at 1,000%. I forget what the lowest was. The highest was on Gab, which is a more far-right platform. Our researchers also noted a steep rise in anti-Muslim hate. Unfortunately, we don't have the sample from before October 7, so we can't do a direct comparison, but we know that the anti-Muslim hate before October 7 was lower than the level of anti-Semitism at that time, and after October 7, it's above where the anti-Semitism used to be. So clearly it has risen significantly. You have a flyer with you now with some of these details on the actual breakdown between different platforms and the amount of content we gathered from those platforms. I'm not going to refer to it in detail, but you can see the actual numbers and the fact that they do vary by platform. This research was carried out by spending the exact same amount of time both on anti-Semitism and anti-Muslim hate. So we carried out 160 hours on each in 1 hour blocks, divided between 10 platforms, so that means actually 16 hours on each platform for each of those two types of hate, which makes these numbers actually comparable. So you can compare exactly how many items we got in each category. What you don't have in front of you, but you do have for the anti-Semitism report, there is a QR code there. The anti-Muslim hate report will be finalised this weekend and then shortly published. And there's a QR code for joining our mailing list if you want the update on that when it comes out. What we have in those reports is a breakdown where every item of hate was put into one or more categories. And we have 11 categories of anti-Muslim hate, and we have 27 categories of anti-Semitism divided into 4 groups. And we can see the nature of the hate that varies by platform as well. We can get really specific, and things do differ between platforms. So if we want to address the problem, firstly, we need the data, but we also need massive improvements. Some would argue for self-regulation by social media platforms to address this problem. Our data monitoring of takedown rates of hate speech, which you have on the sheet in front of you, suggests that this approach has not been working. The best removal rates are around 60%. The worst removal rates are for Telegram and anti-Semitism on Telegram and anti-Muslim hate on YouTube, both of which are a little below 15%. I should highlight that the standard in Europe is to monitor responses within 24 hours. These responses are after at least 4 months. Okay, and in the case of YouTube and Facebook, we actually gave them our sample of data from their platform, and the numbers you're seeing are the improved numbers after they've reviewed them. And I've got to say the Facebook and Instagram numbers from Meta improved a lot. The YouTube numbers improved a bit. Appropriate adaptation also means recognising that the removal of online hate is lower than criminal sanctions. Removing someone's post is a much less serious penalty than putting them in jail. It's also a much lower penalty than a civil penalty, a fine. If we take this into account, then we should be able to accept that the burden of proof can be lower. Not even balance of probabilities, it can be even lower than that. We can accept getting it wrong some of the time if that is the only penalty, right? Provided there is a system that enables it to be challenged and ultimately to be able to go to a court to determine where the line is on some of these issues. So we would suggest that the Online Safety Act and the power of the Safety Commissioner needs to be enhanced, not only to tackle online hate targeting groups, but it needs to be at a low enough threshold that government can intervene and deal with what are currently problems left to the platforms themselves. Finally, as promised, I want to touch on the role of AI. As of last year, it is reported that AI can now, in fact, identify the traffic lights in one of those captures used to determine whether you are human or not. This is big news. We also know, and again, you have examples linked to from the QR code, that AI can now generate images, some of which may constitute hate speech. What AI cannot do at this point is interpret those images, even the images it creates. The AI cannot look at an example of an AI-generated image or a human-generated image, interpret it and say, this is an image of hate speech. The closest it can get is finding images that have been manually coded, and we can get a digital signature, and it can find other copies of that. And that's what we do with terrorist content, for example. Okay, the individual items can be coded. The AI can also read text written onto an image. So an image that has hate speech in the form of text it can deal with. But the stuff that's now being generated and starting to flood the internet, the AI cannot deal with. That means the only way to respond to it is going to be to have users report it, and trust and safety staff, which are the people in tech companies that deal with those reports, manually assess it. Of course, if you've been following the news, trust and safety staff in tech companies since COVID have been slashed. There's very few, and some argue hardly any in some companies, working in this space. The rise of AI-generated content makes their job even more important and raises the need for companies to actually be employing more people to do this. So we need laws for the online world that tackle these unique challenges, that change the nature and increase the prevalence of harmful speech. And the online world, the nature of content being able to go viral, the number of people it affects, and the ability now for AI to generate that content, which can then spread, make this a different situation to the online world and necessitate a different response. Thank you.
Thank you, Andre, and thank you so much for sharing these statistics with us. I'm sure people can look at them and the QR codes in their own time, but it really brings home the importance of your work.